Hi everyone, welcome from Law with Dunk, the Law Guy, and today I'll be spoofing the Fantastic Four as Mr. Lawtastic. I really do know this is a bit weird, but I got carried away and I'm in too deep now with a bit of money invested as well. So anyway, today is day 55 of the Case a Day series journey, covering cases across criminal law, tort law, contract law, and the English legal system. If you ever have a case you want me to cover, pop it in the comments section and I'll get round to it. Today I'd like to cover R.V. Burstow, 1997, and touch upon its relevance to the criminal offence of Section 20 of the Offences Against the Person Act 1861. I only provide this case after the day 54 recording where I covered R.V. Ireland 1997 because there are similarities regarding the facts, and apparently this case was considered by the House of Lords at the same time as R.V. Ireland 1997. I'll first state this case's relevance to a Section 20 offence under the Offences Against the Person Act 1861, and then go on to state how, if the facts were different, it would be relevant to the criminal offence of assault. Firstly, the actus reus, so step 1 of a Section 20 offence, is that the defendant must either unlawfully wound the victim or inflict grievous bodily harm upon the victim to commit the actus reus of this offence. The rules of causation, i.e. step 2, would then need to be proven for the final part of the actus reus of this result crime, ready for the mens rea, i.e. step 3, to be proven, which is where the defendant either has an intent, i.e. direct intent, or recklessness, i.e. subjective recklessness, to cause some harm to the victim. Now, what happened in the case of R.V. Burstow, 1997? The facts of R.V. Burstow, 1997, are that the defendant had previously dated a woman for a brief amount of time and she went on to end the relationship, and Burstow was unable to accept her decision. He subsequently went on to harass the victim over an 8-month period. His behaviour ranged from making silent telephone calls to being abusive when making other phone calls, to sending hate mail to her address, and also handing out offensive cards about the victim to the victim's neighbours. He also would show up at her home and workplace for no reason, and he sent her a menacing note. As a result of this, the victim went on to suffer severe depression, which is key to understanding why the defendant was charged with a Section 20 offence here. I always tell my students that the injury dictates the charge for non-fatal offences. Obviously, if the defendant possessed an intent to cause serious harm, i.e. the mens rea, alongside causing this injury, i.e. the actus reus, then the most likely charge would be that of a Section 18 offence rather than a Section 20 charge here. Furthermore, the appellate court, i.e. the House of Lords, had to consider two things from this case. Firstly, did the psychiatric injury here fall within the definition of bodily harm, i.e. grievous bodily harm, under the Offences Against the Person Act 1861, and secondly, could the defendant be found guilty under Section 20 of the Offences Against the Person Act 1861 where there had not been the direct or indirect application of force upon the victim, which is an interesting point. The House of Lords held that the psychiatric injury here, i.e. the severe depression, could amount to bodily harm, specifically grievous bodily harm, for step 1 of the actus reus of a Section 20 offence, provided it is sufficiently serious, and that the word inflict under the wording of Section 20 within the Offences Against the Person Act 1861 simply means to cause, which is a much wider term, and so there was no need for the direct or indirect application of physical force for a Section 20 offence to occur. As a result, the defendant's trial conviction for a Section 20 offence was upheld by the House of Lords on appeal. Additionally, is this case relevant to the lesser criminal offence of assault? It's more a Section 20 offence case simply because the victim went on to suffer severe depression, which falls within the category of psychiatric grievous bodily harm, which therefore satisfies step 1 of the actus reus of a Section 20 offence, Remember, there is no injury for the criminal offence of an assault, and so RV Burstow is more a Section 20 offence case. However, let's say the victim in RV Burstow suffered a lesser form of depression and not severe depression, then this would most likely be categorised as actual bodily harm under a Section 47 charge, which fulfills step 3 of the actus reus of a Section 47 offence, and would lead to the defendant being guilty of a Section 47 offence under the Offences Against the Person Act 1861. Here, with this hypothetical situation, everything the defendant did to the victim would be considered enough to be acts for the actus reus of assault, and the actus reus of assault here would be step 1 of the actus reus of a Section 47 offence, and the defendant's acts here would therefore most certainly lead to the victim apprehending/expecting the possibility of an immediate attack, i.e. an imminent attack or an attack in the near future, and so the immediacy requirement for assault would be proven here, just like it was in RV Ireland 1997. And that's it for today. Thank you from Law with Dunk the Law Guy, and I'll hopefully see you as soon as I can. I've got a few things going on and I'll need to assign my time to launching the website before September, fingers crossed. I don't want to keep putting it off. So thanks, bye.